Good afternoon, ladies and gentlemen. Yeah. So I need to have, if you can, someone can put my slides up, please. So while I wait, let me say I'm very grateful to Indian Merchant Chamber of Commerce and Industry for inviting me here today for this event. The topic I'm going to speak about today is about the art of doing process reforms. Now, very often you hear about this reform has been done, that reform has been done. What I'm going to do is to give you a flavor of how is it, as a person inside the system, how do we go about thinking about reforms? Why is it that we do something and not others? And give you a sense of the kind of reforms that we have been doing in recent times, so that you understand the process of thinking about how do we identify reform, how do we sort of implement some of them, and so on and so forth, so that you get a flavor of how these changes are actually implemented. So, over the next half an hour or so, I'm going to give you a flavor of a few of these kinds of reforms. Now, I'm not going to talk about just any reforms. I'm going to talk about a subclass of reforms, which is the process reforms. So when very often you hear about government wants to implement reforms, in economic reforms, you will hear the word structural reform. Now the impression you will get is that this is the only kind of reform there is. But in fact, structural reforms are, well, as the name says, reforms that change the structure of something. So there are fundamental changes such as the introduction of GST, the shift to a inflation targeting system, that's a structural change in the monetary policy framework, or insolvency and bankruptcy code, which is a structural change in the way we conduct creative destruction, and so on. But by the very nature of them, these changes are infrequent and happen once in a while. Most of what reforms are is actually about more mundane nuts and bolts changes. These are rule number 43B, subsection D, 3 words have been changed. This is what most reform is. It doesn't turn up on the front pages of any newspapers. People in that particular sector may know about it, but that's about it. If it turns up at all, it will be in the 5th page, small column. But this is the real painful grunge work that has to be done in order to actually keep an economy functioning. So I'm going to talk about these reforms, which are process reforms. These are changes in terms of, as I said, small changes. It could be shutting down of a particular department which has become outmoded, rule changes, and so on. Now, despite the fact that this is such an important area of work, when I got into this some years ago, after I joined the government, about almost 9 years ago now, one of the things that struck me is that although it is such an important thing, there is almost no systematic literature on this issue. Not in academia, not by think tanks, not by anybody else. Yes, individual changes you may get case studies, but there is almost no literature on process reforms as a class. Now this is strange because many of you have done MBAs, you will remember that you will have gone through a course called Business Process Reengineering. This is a common course, it's taught in most MBA courses, and yet there is no public administration course that I know about anywhere in the world which actually teaches you government process reengineering. So what I'm trying to do is to actually begin to systematically document some of them, and as I will show you, we will try and then teach them. So it's not just about giving you a sense of this, but I'm trying to make this a systematic effort so that reforms becomes a part of the DNA of governments at every level, whether it's at central, state, or municipal level. So Here is a methodology that I have devised, mostly derived from the business process re-engineering literature, because that's what exists. I've tweaked it a little bit, but basically, this is a simple sort of system of doing routine reforms. Now, the obvious first one is, why is there a need for a reform? So, as you will see, one of the ways of thinking about this is to look at and compare with, for example, how does the system work in other countries? Or how does a similar system work within our own system? Or just look at the raw data. Does it make sense that a particular rather simple activity takes years when it should happen in days? Or it takes a lot of money? Does it make sense that there is a department which seems to do basically nothing? Should we shut it down? So, first point is to identify an area of process reform. The next step is to actually document the as-is situation. Okay? How does this process work today? And do it in some detail, step by step. Now, this is important to do even if you happen to be doing this every day. Even those who think they know the process, when they formally carry out the mapping, they are shocked by how the process actually works. So this is something that one needs to do. Then, once you have mapped it out, the thing is to find out a process analysis to find the exact issues. Now that I have done literally hundreds of these reforms, let me tell you, you can apply an 80-20 rule. 80% of the problem is usually caused by 20% of the process. In fact, I would say it's even worse. 90% of the problem is caused by 10% of the process, and simply solving that 10% is good enough. You do not need to do major structural reforms. Now, this is why for most things, process reforms are actually superior. You don't need to disrupt the whole system. A relatively small tweak actually gets you most of the effects. Then, of course, you implement it. That's the implementation. And then comes the last step, which is very often forgotten in government, which is monitor the new process and feedback loop. In fact, most progress is made through iterating your way forward. Many of you will know Agile. Agile is good for developing software, but it turns out it's a pretty good way of improving the government efficiency. Sorry about this rather boring background, but this is necessary so that you understand what on earth I'm going to talk about next. I'm going to tell you there are a little bit about the process before I give you actual examples. But after having done a lot of these, I have come to the conclusion that there are roughly 7 types of process reforms you can do. The first kind of process reforms are the simplest ones, which is to revise default lists and precedents. Every large system, it doesn't only the government, even in companies, function because there is a certain default on which it functions. Nobody knows why it functions like this, but this is how it functions. Now, going there once in a while and looking at why it functions in a particular way and revising it is a rather simple thing, because it's actually not embedded in any law or regulation or something. It just happens to be done that way because it is. And you will be surprised by the thousands of things, inefficient things that go on in any large system that can be improved by simply paying a little attention to it. Now, I happen to live in Delhi, and Delhi is where the diplomatic community lives. Now, one of the things I have noticed is that the invitation list of virtually every embassy is essentially a default list. Every new ambassador comes, adds a few people. Now, if you say something particularly rude about that country, maybe you will get deleted. But by and large, that same list carries on from one ambassador to the other. The net result is when you go to these embassy parties, one of the things you do is you'll meet all these people who were famous 30, 40 years ago, and you had assumed that they were dead. By the way, we do the same thing when in our embassies in other countries. So we shouldn't laugh at other countries because we also do the same thing. But this kind of thing goes on across the whole system. Some time ago, I was re-looking at the list of national monuments. We have 3,600 odd national monuments. I discovered that except for a few additions that were made post-independence, almost all of them were inherited from the British period or from the princely states. So basically they are from the British period, whether it's from the British government or from the princely states. We have actually not edited that list in these 80 years we have been independent. So much so, even today, there are dozens of national monuments in Delhi, not in some remote area, in Delhi itself, that are of obscure British officials. For example, Nagaland has 4 national monuments. 3 of them are of obscure British officials who even people in Nagaland do not know who they are. They are PWD engineer and people like that. Some local tribesman killed that person, so a monument, small monument, not smaller than this stage also, was built, and it is a national monument, and all the rules and regulations that apply to the Taj Mahal also apply to them. So now there is a new effort that is now being made to clean it up, but the absurdity of it. But the best bit is, in Delhi itself, I discovered that there was a monument which was done to a British era general called John Nicholson. Now, John Nicholson, interestingly, was the person who carried out the sacking of Delhi after the Great Revolt of 1857, and he carried out a big massacre. The British put up a big statue to him after he died. They were, of course, grateful to him. But what is interesting is that that statue in front of Kashmiri Gate, by the way, continued to be a national monument after independence. Now, in 1950s, the government of Northern Ireland wrote to the Indian government saying that now, presumably, you don't have any use for this statue. Why don't you give it to us? So the government of that time wrapped up the statue in bubble wrap, I assume, and sent it to Northern Ireland, where it is put up in his village, where it is standing there. But we did not delist it from our list of national monuments. So the empty space continued to be a national monument till I discovered it 3 years ago. You'll be pleased to know that in end 2024, I finally managed to get it delisted. So there are many such things that need to be done. So this is just one example. Type number 2. There are existing administrative processes that need to be streamlined. This does not very often require laws to be changed or even regulations to be changed, but there is a process and you can change it. Type 3, changes in a given law. So you actually need to change, first is changes in regulations under a given law, subordinate to the law. And then changes in the legislation. Now this is more complicated, obviously, because you have to go back to Parliament and change it. Then there are type 5, which is adding some capacity at certain bottleneck in the government. So you may need to add some capacity. And then, of course, removing requirement of a state mandated activity or a process, right? You are from the commercial system, you will find that there are many state mandated activities that are inserted into a relatively smooth process, or a process that is not working but you want to improve it but has actually worsened it in some fashion. And this happens all the time. Removing them is an important part of making it smooth. I'll give you one example. Many of you will know, you're conversant with something called mediation. Yeah? Mediation, for those who don't know, is a pre-litigation process. The hope is that you get people into the same room and they sort it out amongst themselves so you don't have to go and deal with this overburdened legal system. Good idea. I have nothing against mediation, except that about a decade ago, we actually introduced a law making this mandatory for commercial cases. So for commercial cases, if you have a dispute, you have to mandatorily go through the mediation process. Now, it turns out that this doesn't work. I collected data from 2 commercial courts in Mumbai, and it turns out that between 98 and 99% of all commercial mediation fails. And yet, you are forced to go through this process. All it does, it adds 6 months to an already long process. You pay legal fees, and everybody is trying to find some 12-way loophole, right? What a waste of time. So, removing these kinds of state-mandated activities is one part of it. And then type 7 is merging, closing, and restructuring outdated government agencies. There are lots of them. I'm currently in the process of mapping out the central government, but I have been doing this for quite some time. Even when I was at the central in the finance ministry as principal economic advisor, I was involved in removing many of these. So, give you an example of how outdated government agencies can somehow continue to living in the system and surviving. So, some of you are old enough perhaps to remember that before we liberalized our economy in 1991, there used to be a body called BICP, Bureau of Industrial Cost and Pricing. Yeah, these were the guys who used to decide the pricing of various commodities. This grade of steel will have this price, aluminium, cement, and so on. So you can imagine it was a very, very powerful body. And of course, you can imagine, the potential there for rent seeking and other things. Now we liberalized the economy in 1991. This body, which was headed by a secretary level official and was one of the most powerful bodies in the country, suddenly had no power at all because these prices were now being set by the market. Now you would think that this body, which was, by the way, had 2 full floors in that ugly grey building behind Khan Market, with some 200 odd people working in it. This body, however, was not shut down. It continued to exist into the 90s till they discovered that maybe there is a danger if they continue to be called BICP that somebody may discover them and shut them down. So they renamed themselves the Tariff Commission. Except it had nothing to do with setting tariffs. It was in the wrong place. Tariffs in India are set by the Commerce Ministry to some extent, which advises the Finance Ministry, specifically the Board of Indirect Taxes. That's how tariffs are set, and as they should be. This particular body, Tariff Commission, was in Department of Industrial Cost, DPIIT. So DPIIT has no role in the setting of tariffs, and yet it survived there till I discovered them in 2022. So it had existed from 1991 when it became defunct, renamed itself in 1998 or so as Tariff Commission, until 2022 essentially continued to have over 100 people still working there. Many people had joined and retired from there without ever having done anything particularly useful. So when I discovered it, I sent up a note, and then finally it was shut down in, I think, 22 or 23. Of course, many people became very annoyed with me for pointing out this, and many complaints were sent about me to the then cabinet secretary. But nevertheless, we managed to close it, and as far as I can tell, nothing terribly bad has happened as a result. So now that you have a sense of the kinds of things that are done as a part of process reforms, let me take you through a few case studies you should be familiar with, and I'm giving you cases that I am personally involved in, so I can give you details that you want. Here is an example. Voluntary liquidation of companies. Okay? Now, voluntary liquidation of companies till very recently was a very difficult thing to do in this country. Now, this is not about companies going insolvent or bankrupt. 90% plus of companies that are shut in any country in any year are basically voluntary. Some old man was running a company, kids are not interested, he shuts it down. Some company was set up for some special purpose, need to shut it down, and so on and so forth. Nobody is objecting to its being shut down, and yet it used to take years to shut this down. Some of you may have attempted to shut down a company, will know this. So I began to look into this a few years ago, and I discovered that there are basically two ways of shutting down companies in India. One is, the main way is Section 248(2) of Companies Act 2013, and the other is through IBC. The IBC is really useful for very big companies, but let's talk about this first, the Companies Act. Now, till about 3 years ago, when we looked into this issue, we found that there were at that time 28,500 odd pending cases, of which nearly 10% of them had been pending for 1,000 days. And for no particular reason. Mind you, nobody is objecting to shutting them down. 54% of them were pending for more than a year. Now, as you all know, if you keep a company running, you still have to do all the accounts, etc. It's a headache lying on your head. And yet, this was the situation. On average, this is just the average, it used to take about 500 days to strike off a company till the year 2021-22. So, what do? I showed you the methodology. We first did the as-is mapping of the system. So we found that how does the company have to shut down? So the step one was company had to convene a board meeting, fair enough, approve the closure, pay off the pending liabilities, etc. And once this is done, the company files STK2 form with ROC along with the requisite fees. So far, okay, nobody is objecting. Then comes step 3. The director has to furnish declaration in e-form citing the company does not have any dues to the government department. This is certified by a chartered accountant, company secretary, etc. And the STK2 form has to be accompanied by a copy of the resolution, the indemnity bond, notarized, etc. Okay, that's also fine. Then came step 4. The ROC was supposed to put up a public notification in a prescribed manner on the official website of Ministry of Corporate Affairs, an official gazette, and in the largest circulating newspaper, one in English and the other in an Indian language, giving 30 days notice for any claims and objections to be raised. Okay? Now, objections of any from external agencies had to be submitted within 30 days. Now, this is a good point in theory, but in practice, this could take you years. And in fact, there was a small industry of brokers who could kind of, let's say, grease the process towards getting you your advertisement. And after this whole thing, the ROC was supposed to strike off the company and publish the dissolution. This also could be sometimes take some time. So we went through this list and we discovered, as I said, huge delays in publishing the strike off notice in the newspapers by the registrar of companies. This was, as I told you, very often the 90-10 problem. This was where the 10% of the, it's not even 10, it's a 0.5% of the problem, and 99% of the time used to go. And there were no strict guidelines for the ROC to follow. In fact, I managed to get hold of a rate card from the ROC of how large the turnover of the company, how much you had to pay the brokers to get this done. And of course, there were various NOCs, etc., that used to also take time. So what did we do? The solution? Well, we started with the key thing of resolving this advertising problem. But then we came up with an even better solution, which is a centralized processing of accelerated corporate exits called CPACE. It's a website which came out 3 years ago. And we designed it in a way that it's a transparent system with no physical interface with applicant, broker, etc. Company puts in its stuff into the CPACE system. The CPACE basically has a fixed series of steps. Nodal officers from each department that needs to give NOCs, etc. is known. If within 30 days they do not give any objection, the system directly sends the advertisement up. A list is created. The ROC is allowed to have an objection, but here also number of resubmission requests are limited to 2. And after that, the thing goes out for the advertisement. And guess what happens as a result? This is what has happened. What used to take average 499 days now takes 60 days. And incidentally, this is faster than even, it's the fastest in the world. It is faster even than Singapore. Because I have at one point shut down a company in Singapore and it took me 6 months. Here is the other method of doing it. I'm going to skip through this because it's analogous, but Section 59 of the Insolvency and Bankruptcy Code, this is for large companies. And while this is for relatively few companies, but these are high value items, so they do matter. And out of the total, we found when we did this research in December 2021, that out of the total, final reports had been received for only 49% of the cases, and the final order had been passed only for 25% of the cases. And of the ongoing cases, 35% were going on for 2 years or more. So this just went on and on. So again, same process, as is mapping. Step 1 was obviously the board part, which is fine. Passing the shareholder resolution, step 2, that's also fine. Then the liquidator filed the resolution to IBBI and ROC within 7 days, and then regulation was supposed to put the announcement within 5 days, and then opening a designated bank account for cash, liquid funds, etc., and closure of bank accounts. So you had the usual creating of a nostro account and all that. Then came the interesting part. This was the point at which most of the delays in this case happened. It was to apply for a no objection certificate to the Central Board of Directors, Direct Taxes, Central Board of Indirect Taxes and Customs, Employee Provident Funds and sectoral regulators. Now, the funny part is that we discovered that it is these compliance requirement of this NOC is not explicitly mentioned in the code. Even though there is a vague implication about it, so nobody knew whether you were or not supposed to get it, what form it was supposed to do, and whether or not these departments were supposed to give the NOC. So now you have a weird situation where the NCLT expects these and those departments don't want to give it to you, but you need it. But imagine the Kafkaesque situation. Now if some good soul in one of these departments were willing to give you an NOC, good luck. But otherwise, you couldn't force anybody. There was no nodal officer. It was nobody's job to do this. And then, of course, there were other steps. Liquidator gives final remittance to shareholders. Liquidator then submits a final report. Order is passed by NCLT, file copy of dissolution, and so on. But step 5, that was the main problem. So, since delays in NOCs from various, the point I made is, the code did not mention this. And there was no standard operating procedure within the department. And as a general practice, the liquidators used to write a letter to the heads of department asking for any claims to grant NOCs, and the lack of guidelines when the NCLT bench may or may not accept that NOC also, because by saying that it came in the wrong format and many other excuses. So again, in November 2021, and by the way, I did this while I was still in Finance Ministry, we managed to get this clarification in November 2021, which stated that therefore it is hereby clarified that as per the provisions of the code and the regulations of section 178 of the Income Tax Act 161, an insolvency professional handling the voluntary liquidation process is not required to seek NOC, NDC from Income Tax Department as part of the compliance process. So the whole thing was not required. Okay, and then voluntary liquidations were regulations amended properly in April 22, bringing in requirement of submitting a compliance certificate, Form H, along with the final report. This compliance certificate essentially has a checklist with all the details. So it's just a checklist. So now this is what the checklist looked like. So by this point, I had moved to Prime Minister's Economic Council, but I was still working on these. And it's very important, as I said, you have to be at this over long periods of time, taking feedback with every step. Did it work? If it didn't, and so on. So we created this checklist. Now, basically, once you've completed this checklist, you're done. So it's clear what you're supposed to do. You get all these pieces of paper, you're done. And look at what happened. Look at how the percentage of cases under voluntary liquidation has dramatically gone up. Final report submitted for 78%, closed 59%. Look at where it used to be in 2020. Now I'm going to give you a second example, something that I've been working over the last year myself. This relates to the Investor Education and Protection Fund. Now, this is a room where you probably know what this is, as and you will know. It is extremely doubtful whether it either educates or protects anyone. For those who do not know, this is basically where your shares go to die. Now, supposing you have a grand aunt who left you a lot of some large, 100 crore worth of money, and you are very excited about getting it, then let me tell you, till very recently, your chances of getting the money were lower than your chances of actually meeting your grand aunt in the afterlife. So we discovered that when I began looking at it about little over a year ago, that as of March 2025, there were more than 51,000 applications pending with IEPFA, and there were unclaimed shares of 78,000 crores plus dividend of 10,000 crores. So by now it would have, if it had kept going, we would have easily exceeded 1 lakh crores worth of these shares. Now, while researching it, we discovered that for those who got their money back, it took about 3 years for getting the shares and dividends back. 3 years. Now, this is for those who persisted. For bulk of the people actually just gave up, or they employed again a broker who would charge up to 20% for getting your money for you. So this was the kind of situation we were till a year ago. Again, now you know my methodology. Basically, go through the as-is process. So what did I discover? Now, I discovered that there were actually 25 separate steps to get your money and dividends back, to get your shares and dividends back. 25 steps. Not only that, these 25 steps were spread over 3 separate portals. Now, how many of you actually attempted to get your money through this process? Has anyone here? There are some people who have attempted to get 3 separate portals, okay? One of those portals is for the first set, for getting the approval. Second, once you've got the approval, you have to take it to a second website in order to actually claim the money to give it back to you. And there is a third website and separate website for getting the dividends. Now, whoever actually designed this must be given the Nobel Prize for Economics. And you can imagine the number of human errors there can be from entering all the huge amount of details you have to put in. And if on the 24th step you got it wrong, you had to go back to step number 1. So now you know for sure that the board game Snakes and Ladders was invented in India. This is proof. Now, how many of you really want me to read you through all the 25 steps? So this is the first 7 steps. This is the next. Some more till step number 17. Step 25. Okay. Now when we mapped all of these steps up and showed it to IEPFA, those who had worked in this for years were themselves shocked. Because you see, here is how government functions. Those who used to the front end of this had never bothered to find out what happened at the bottom end. So there were people who had worked for years on step number 3, 4, 5. But they had no idea what happened at step number 17, 18, 19. And mind you, while they're, I mock civil servants all the time, but sometimes you have to feel sorry for those guys. Some of them are sincerely working away on those 3 little steps for years. And they're really working hard, and the amount of things that are being dumped on them is just impossible, because there is no way. There is like 2 guys given 50,000 cases where he is supposed to do that one little step. It is soul-sapping work, and you have no sense whether it's heading anywhere. So when I showed it to them, actually, even for many people in IEPF, it was an aha moment that this was the problem. They also discovered this problem of having 3 portals. So since then, we have managed to do the following. The entire process as I said, had been in 3 steps, not separate. It used to be those 3 portals were called MCA portal, MCA 21 portal. Then there was the depository for CDSL and NSDL portal, and the PFMS portal. Those of you who like these acronyms will love this. I have no idea what they mean, but anyway. So we did take this up. To be fair, the IEPFA team was very, very cooperative. And I have to say, the MCA teams, both for solving the voluntary liquidation and for this, they really went out of their way to work on this. And so the IEPFA, the head of IEPFA, Madam Akela and her team really worked on this, and we began to finally find ways of basically trying to run some part of the process in parallel, but first of all to simply merge those 3 websites. Simply merging those 3 websites such that you didn't have to take all this information meant that a lot of the human error just disappeared. And then we basically simplified the whole thing. And so we managed to got rid of all those manual processes, and as a result, we managed to reduce the number of steps from 25 to 15. So in one shot, we managed to reduce the number of steps from 25 to 15. This transfer of shares and dividends now happens parallelly. And since all the portals are linked, the data is automatically fetched from wherever you want. So you need to do it. So as the result, the transfer of shares and dividends is now possible within a few days. What used to take 1 to 1.5 years at a minimum, even without the other delays, is now taking a few days. Here is some flavor of how it looks. So the new system came on stream. The new system came on stream on September 25th. Before that, you can see the number of monthly approvals the system was doing. And mind you, those guys were working hard. But this is what they were. Now, same bunch of people, same files, same legislative framework. We have not changed any laws here. And look at what has happened. We were doing basically 850 odd approvals a month. It went up to 3,600 in October, 7,500 in November, December 11,000, January 8,800, February 12,000, and March 14,500. At this pace, we will have completely done the entire backlog in the next few months. By September this year, the backlog will be gone. In fact, this number will come crashing down because the system will be more efficient than the number of claims. What we now are working on is to improve the search engine, which is still not up to speed. But if somebody comes to us, we can clear this very quickly. The search engine, as I said, searching for your shares will become a lot more easily, and your grandma aunt in heaven will finally be able to feel be at peace. Again, that is the number of approvals. In case you want to know, another way of thinking of the same data is to look at the number of shares transferred. You can see we are now transferring almost 300 lakh shares. 300 lakh shares in 6 months, sorry, not every month. This is in the 6 month period. We have done 3.5 lakhs shares. And in case you think we are just, managing to pump this through by rejecting everybody, this is what is actually happening. Earlier, you can see almost 3/4 were rejections. Why? Basically, one way of keeping the file moving is just to reject on trivial grounds. On paper, you have dealt with the case. So the case load is maintained at some reasonable level, but essentially what you're doing is you have rejected him, thrown the person out. Look at what has happened now. 3/4 of cases are being approved. Now, I'm going to talk about something I think we should now do. So far, all the things we have done. Here is a change, a process reform. In fact, I would argue it's big enough that it should perhaps even be called a structural reform that I'm pushing for. Maybe I'm trying to naturalize the idea. It's a simple idea, and the idea is the following. That for India to be a Viksit Bharat, we need a situation where the businesses and citizens need to be clearly told what are the rules and regulations we are supposed to follow. Because in the court, we are told that ignorance of the law is not a defense. If ignorance of the law is not a defense, it stands to reason that there should be an easy way of finding out what the law is. But in fact, it is impossible to find out what the law is in this country. There's a very complex set of circulars you'll have to go through. Even something as simple as traffic rules, you will not be able to easily find. In fact, when I began to make a fuss about this particular issue a few years ago, I tried to find out how to find out Delhi's traffic rules. What are the fines for different? And I could not find it easily. After a lot of hunting down, I did find it, and it gave me wrong information. So I wrote about it in the newspaper. Delhi government, of course, responded to it, and today Delhi Traffic Police is the only one that you will find online where the traffic rules are clearly stated and what are the fines. I'll be very surprised if you check on your phones if you can find them from Mumbai. Now, you can imagine this is a very basic thing and a very everyday form of harassment and rent seeking by agents of the state. And yet, we all accept it. So, I'm proposing something called a Transparency of Rules Act. What will it state? It will state that every agency of the government needs to put in one place, it could be the India Code website, wherever, it needs to put the rules and regulations that a citizen has to follow. Okay? The first point about this act will be, if a law is not placed on the site or is wrongly stated on that site, that is the law that is the law of the land until that law is changed. So if by mistake you have said that to get a driver's license, I have to learn Bharatnatyam. So if I have learned Bharatnatyam, I am to be given my driver's license till you have changed the rule. Fair? Next. The laws and regulations and rules should be placed and presented in an updated, unified whole. In other words, it is not the job of the citizen to figure out what the law is by going through every circular. Not a difficult thing. We live in the world of Wikipedia. Most of the laws are anyway online. How difficult is it to present it to me in its current form and not as a series of circulars? Not difficult. 3. Torah should specify that the portal and websites clearly timestamp the date and time at which each change was made. This is important because then officials cannot retrospectively change something. Every change is clearly stated, so I know that on the 1st of January on 2023 at 9 o'clock, this was the rules that applied to me. If the rules were changed at 10 o'clock, not my problem. So together, these three would have a radical improvement in the interaction between the citizen and the state, because it is a contract. The contract between the citizen and the state is that the citizen will follow the law of the land, but only if they should have a fair chance of finding out what the law is. So I'm pushing for this. I'm trying to naturalize this over time in the hope that it will build up public pressure to have a rule like this, a law like this, legislated by the parliament of this country. Interestingly, we actually have an example of this of a sort in the form of the RBI's master circular. So it's something that we have already done. Till very recently, that is till the end of last year, we had the same problem with RBI. Large numbers of circulars, nobody knew what was supposed to be applicable. But in November 28, 2025, the RBI announced that the 9,446 circulars, something like 3,800 of them would be subsumed into the 244 master circulars that are now the current set of laws. 5, 6, 7, 3 of them were repealed as obsolete. They do not apply. And so we now know, at least when dealing with the RBI, what is the law of the land. Importantly, the consolidation was carried out as an as-is basis. So this is not a case of the laws being changed. All the RBI did was tell you what the law was. Okay? And so this is what has been done, and this master circular has been a huge success. We have now been functioning for about 5 months, and we have had very, very good response to it from industry. But to conclude, what I am trying to do here is to let you a flavor of how the government is thinking about process reforms and ease of doing business and ease of living. These are nuts and bolts reforms. These are not structural reforms, these are process reforms. But as I told you right in the beginning, most of reform is about doing these kinds of changes. Importantly, here are the 4 things you must remember. Map the existing process, identify that specific bottleneck that causes most of the problem, take action, and then very importantly, feedback loop and track the results. With that effort, slowly but steadily, India is creeping forward towards Viksit Bharat. Thank you very much, ladies and gentlemen.